have a hearing in the appeal in the matter of the child.
Morning,
My
Mr. Gordon.
ladies, morning, my lady. My ladies and my lords, yesterday I had finished the first two of my core propositions, and I had reached core proposition 3,
Yes.
which is that the MCA, whether considered in isolation or in conjunction with the Children Act, does not cut down the scope of parental responsibility in domestic law. And it isn't even asserted now that, in isolation at least, the MCA does have that effect. But it is perhaps necessary to emphasize a few elementary principles of statutory construction. The first being that where one is changing the law, where Parliament intends to change the law, it is a presumption that it will use express words or necessary implication produces such a result. And if authority was needed for that, it's first of all provided in Bennion. I'll give you the tab reference, Authorities Volume 9, tab 96, memory stick page 2830, for the proposition that there remains a general presumption that Parliament does not intend to make changes to the common law. And that presumption is exemplified in the cases. First of all, we cite Pearson, Authorities Volume 3, tab 25, memory stick, page 783. One speech we cite in our case at paragraph 31, that's Lord Brown-Wilkinson. It is well established that Parliament does not legislate in a vacuum. Statutes are drafted on the basis that the ordinary rules and principles of the common law will apply to the express statutory provisions. Parliament is presumed not to have intended to change the common law unless it has clearly indicated such intention either expressly or by necessary implication. And
Would
in
you
the same
mind giving
case,
us the page reference to that quotation?
yes, that is page 573G, memory stick page 817.
Thank you very much.
And in the same case, Lord Steyne said at page 587C to E, memory stick page 831, and I'll read it, it's not in our case, the presumption that in the event of ambiguity, legislation is presumed not to invade common law rights is inapplicable. A broader principle applies. Parliament does not legislate in a vacuum. Parliament legislates for a European liberal democracy founded on the principles and traditions of the common law, and the courts may approach legislation on this initial assumption. But this assumption only has prima facie force. It can be displaced by a clear and specific provision to the contrary. For at least a century, it has been thought to be in the highest degree improbable that Parliament would depart from the general system of law without expressing its intention within these words we rely on, irresistible clearness. The general words of the Act are not to be so construed as to alter the previous policy of the law unless no sense or meaning can be applied to those words consistently with the intention of preserving the existing policy untouched. And finally, for the same set of propositions, Lord Wilberforce in Shillow's Spinners Limited against Harding, Authorities Volume 2, tab 16, memory stick page 491, and in the report at page 725A to B, in my opinion, where the courts have established a general principle of law or equity, and the legislature steps in with legislation in a particular area, it must, unless showing a contrary intention, be taken to have left cases outside that area where they were under the influence of the general law. To suppose otherwise involves the conclusion that an existing jurisdiction has been cut down by implication by an enactment, moreover, which is positive in character rather than negative. So that's the principle.
And again, would you be kind enough to give us the page reference?
Yes, page 725A to B, memory stick page 491 at 525.
491.
At 525.
At 525.
So those are clear principles, and plainly it's not even contended by the appellant that there are express words. Can such a result arrive by necessary implication? Well, again, it's not contended that the MCA in isolation contains that necessary implication. And certainly we would submit the absence of reference displaces the proposition that Parliament intended with irresistible clearness to abrogate the scope of parental responsibility at common law in the Mental Capacity Act. In addition to the points on express words or necessary implication, one only has to look at the various Law Commission reports to see that no necessary implication can be derived from the Mental Capacity Act in terms of cutting down the scope of parental responsibility at common law. There are the paragraphs already cited by the Secretary of State in his case. The first paper, 1993, paper 128, paragraphs 3.4 to 3.6. I'll give you the references without taking you to those paragraphs. Memory stick page 2664 to 2665, volume 8 of the Authorities, tab 83. And similarly, in the second 1993 consultation paper, number 129, volume 8, tab 83, again, memory stick page 2666, paragraphs 2.22 to 2.23, at memory stick pages 2669 to 2670. And those paragraphs show, we submit, that the Law Commission said that its intention was that the power of parents in the exercise of parental responsibility to consent to medical treatment on behalf of 16 and 17-year-olds should continue to run alongside the new mental incapacity jurisdiction. Moreover, the appellant's argument in its case at paragraph 65.2 and footnote 99 that the MCA provides a comprehensive framework in relation to treatment and, quote, to this extent replaces the more limited framework in section 3, subsection 5 of the Children Act, we suggest is undermined by paragraph 2.10 of the first 1993 consultation paper. And if I can refer you to our supplementary bundle, or bundle 10, I think we may have called it.
Sorry, paragraph?
It's supplementary bundle, my lord.
Yes, the reference within
paragraph 2.10.
Thank you.
And it is at tab 118.
This is from?
This is from the first, it's the 1993 first consultation paper, 128. We see a much stronger case for clarifying in statute the authority which informal carers have in relation to the people they are looking after. This will not only reassure them of the legality of the actions and decisions they currently take, but also encourage them to act where it's reasonable to do so. At the same time, the limits of that authority and the circumstances in which resort to administrative or judicial body is required could be spelled out. Section 3.5 of the Children Act 1989 offers a useful model for such an enabling provision. The object of this provision is not to confer any new power upon carers, but to clarify the power and indeed the responsibility they already have. So the point we make about that is that if Section 3, subsection 5 of the Children Act was intended to provide a useful model, it is unlikely in the extreme that the Mental Capacity Act was intending to cut down the scope of that provision. And the final passage in the Law Commission reports of interest is in the 1995 paper on mental incapacity, paragraph 720, and you see this at the next tab in this supplementary bundle, tab 119, tab 120.
120. So what is 119?
No, it is 119, sorry, it is 119. It's the second page.
Doesn't look very.
And it's really halfway down the page, where CPA's continuing powers of attorney are concerned, it would not be satisfactory to rely on the fact that a minor has power to avoid transactions by an attorney. There may be physical, emotional, or psychological consequences of a personal welfare or healthcare decision which cannot easily be reversed by the payment of a compensatory sum of money. Since a CPA may cover personal welfare matters and healthcare decisions, there would also be very significant complications with the law in relation to parental responsibility and the inherent jurisdiction of the High Court if a CPA could be created by a minor. And there, parental responsibility being used interchangeably with inherent jurisdiction, and we know from the case of L, which I'll come to in a moment, that the inherent jurisdiction was undoubtedly not replaced by the, in any way, or cut down by the Mental Capacity Act. So that's our first reason why we say that the MCA has not cut down the scope of parental responsibility at common law, no express words, no necessary implication. The second reason why we make that submission is that the MCA cannot sensibly be argued to have ousted the common law because it contains no specific regime for children aged 16 or 17. It contains no exclusion of parental responsibility. It contains no discrete statutory role for those exercising parental responsibility, thus reinforcing our submission that the common law and statutory position under Section 3 remains unchanged. And see also judgment of the Court of Appeal at paragraph 127, memory stick, page 3279. Our third reason is that we say the MCA leaves the scope and operation of the Children Act unaltered. There is no provision explicitly or impliedly ousting the operation of the Children Act in the MCA. And if that's correct, it seems to us that there is nothing in the Children Act itself that cuts down the common law ambit of parental responsibility as articulated in Gillick. There are some submissions by the appellant to the effect that some sections of the Children Act show a parliamentary intention to legislate differently for children of 16 to 17. But we submit that, apart from the implausibility of that as a submission, having regard to the structure of the MCA, there is nothing in the provisions of the Children Act that operates to cut down the scope of parental responsibility at common law. So, first of all, reliance is placed by the appellant on Section 9, subsection 6, Section 20, subsection 11, Section 25, and Section 31, subsection 3, where there are different provisions for children aged 16 to 17. But the arguments, we say, with respect, go nowhere, largely for the reasons set out in the Court of Appeal's judgment at paragraphs 125 to 127, see memory stick page 3278 to 3279. As regards Section 9 of the Children Act, as recognised by paragraph 127 of the Court of Appeal's decision, what this section is about, Section 9, just to remind the Court, is at memory stick page 18, volume 1, tab 1 of the authorities bundle. And it's, in fact, it's at memory stick page 19. It provides that no court shall make a Section 8 order which is to have effect for a period which will end after the child has reached the age of 16, unless it's satisfied that the circumstances of the case are exceptional. And the point that the Court of Appeal made, and the point that we make, is that this section limits the power of the court to make an order, but it has no relevance to the scope of parental responsibility of a parent. And similarly...
Do we know what the Law Commission report, which led to the enactment of Section 9, said about that?
We don't have that material to hand, but we can certainly provide...
Well, I'm sure I can look it up for myself, but I'd be quite interested to know whether it said anything about the scope of parental responsibility in relation to 16-year-olds. I suspect it did. But I can't remember.
We'll check that.
A long time ago.
We'll check that, my lady. But similarly, with those you may make the same points with other sections. Section 20, subsection 11, same volume of authorities, memory stick page 26. Top of the page. and it's really the end of section 20. Subsections 7 and 8, and subsections 7 and 8 relate to the fact that the local authority may not provide accommodation if any person who has parental responsibility is willing to provide accommodation, etc. Do not apply where a child who's reached the age of 16 agrees to be provided with accommodation under this section. So it says nothing about nor excludes the scope for exercising parental responsibility so as to override the wishes or feelings of a 16 or 17-year-old lacking Gillick competence. And as regards section 25, which we find a few pages on, at memory stick page 32, as the appellant would contend that the circumstances of the confinement in this case were, to use the appellant's words, in effect, secure accommodation. But examined more closely, we say that is plainly not the case. So first of all, in relation to section 25, there is no best interest component, a necessary element of what we say to be necessary for the valid exercise of parental authorization of confinement. The child can be subject to a section 25 order where the only object is preventing injury to others. Indeed, the welfare checklist does not apply. So it's a completely different scenario from the present case. And if authority is needed for that, see paragraph 37, subparagraph 8 of the case of Re P, Authorities, volume 5, tab 49, memory stick pages 1588 to 1589. Similarly, as Mr. Justice Kean held in Re A B, Authorities, volume 6, tab 56, memory stick 1860 at 1870, a secure accommodation, I'm quoting from his lordship's judgment, has a punitive quality to it. The paragraph, by the way, is 31. It is designed for young people who are looked after by a local authority, who by reason of their actions are likely to abscond and thus suffer significant harm or injure themselves or others. The second point about a section 25 order from the facts of this case is that it's plain that this is not a case capable of meeting the level of a secure accommodation order. By contrast with a secure accommodation order, these circumstances as summarized by the Court of Appeal in its judgment at paragraph 10, see memory stick page 3237 to 3238, comprise the following elements. First of all, he was permitted to leave the placement when escorted, for example, for planned activities. He was not initially allowed unaccompanied access to the community. He was being supported too, rather than strictly supervised, throughout his day to engage in the activities comprising his routine. His routine focused on activities around him, leisure activities in the afternoon, meals out, etc. And his access to internal spaces within the placements depended on the activities he was doing, rather than some other criterion for restricting access.
How do we know that's different from how it would be in a secure accommodation?
Well, precisely because you're not looking at best interests. You're looking
No, the practical arrangements. You're saying this isn't secure accommodation that he's in because his practical arrangements are not the same.
Well, that's one reason.
How do I know that?
Well, we know what the practical arrangements were because they were...
No, we know what his were, but
yes.
How do we know what they would be in secure accommodation?
No, but the point about... Well, I was going to come to the next point. The secure accommodation has criteria attached to it.
Yes.
Do not apply to this case.
You've made that point already,
Yes.
but what my lady, if I understand her correctly, is interested in is what, to the person in the accommodation, is different between being in secure accommodation and being in the sort of placement that Dee is in.
Well, it's a far more
That's
restrictive...
exactly it.
Yeah.
It's a far more restrictive environment because its purpose is to contain.
But how do we know that?
Well,
Have you ever been to secure accommodation?
no, but I've been told about it. I know the general... the trouble is a lot of this is anecdotal. and therefore it's a bit difficult for me to put it forward as a submission. But
It's accommodation provided for the purpose of restricting liberty.
yes,
And I
That's its
think
purpose.
under the regulations it has to be nominated in some way. But the whole point about this is that we're talking about confinement, which is restricting liberty. Otherwise, we're not in Article 5 at all.
but the dominant purpose is not to support the child. The dominant purpose is to restrict liberty. That's the difference. Now, in some cases...
Well, no, I'm not even sure I would agree with that. The dominant purpose is to prevent the child or somebody else suffering harm, or to prevent the child running away.
Well, if I could just show
Sounds a
you...
bit like the purpose of
If
one
I
of the
can-
purposes of D. And obviously it's meant for the benefit of the child as well as for everybody else.
If I can show you Re K, which is Authorities Volume 3, tab 27. So this is paragraph 22, and it's F, submission by counsel. She submitted that in a secure unit, by its very nature, a child was deprived of his liberty. He could not leave the premises and was locked in his room at night. The purpose of Section 25 was to restrain children who would otherwise be likely to abscond. In order for a local authority to place the child in a secure unit, it had to obtain the authorization of the court for any period exceeding 72 hours. The requirement to get the authorization was a good indication that a secure accommodation placement went beyond the extent to which a parent could lawfully restrain a child. And then at paragraph 20,
Sorry, what memory stick page?
page 871, my lady. And then at paragraph 29, that submission appears to have been accepted by the President, applying those principles to the application of a secure accommodation order. As set out, it's clear the purpose of Section 25 is to restrict the liberty of the child. It is a benign jurisdiction to protect the child as well as others, but it's nonetheless restrictive.
Well, of course. Of course. But it is benign as well.
Benign, but not best interests. And therefore outside the scope of parental responsibility.
But what I'm interested in Section 25 because what it tells us is that for a certain category of children, if their liberty is going to be restricted in this way, the court has to be involved after, I think, 72 hours.
Yes.
So what does that tell us about other children who, this relates to children who are being looked after by a local authority? Actually, this child was being looked after.
Yes. But
So what took it out of the Section 25 regime? Presumably that the place he was in was not one of the places registered under the regulations.
yes, absolutely, and permitted, therefore, to be the subject of parental responsibility. A parent was permitted to consent to confinement.
Well, that's the whole argument.
Well, that is the argument, but certainly...
It doesn't prove that the argument... It may be correct, Mr. Gordon, but it doesn't prove it.
No, it doesn't prove it, I agree. A further piece of the jigsaw is that Section 25 accommodation was described to and by the European Court in Koniarski as akin to a medium to high security prison for adult offenders. And we find that in the Authorities Volume 7, tab 70, memory stick pages 2244 to 2245, especially at page 2245. So we say that there is a qualitative difference between an ordinary Section 20 placement and a Section 25 placement. It may be one of degree, but that is the cut-off line. And indeed, it was the fact that that was the cut-off line that was distinguished by the Court of Appeal in the present case. And in any event, we submit that Section 25 operates to constrain only the powers of local authorities and public bodies to deprive a child of their liberty. It says nothing about the powers of parents. Parents are not one of the decision makers falling within Section 25 or the attendant regulations, which are the Children's Secure Accommodation Regulations 1991, see Volume 2, Tab 11, memory stick page 345.
So are you saying that parents could consent to the accommodation of their children in Section 25 accommodation? Are you saying that?
No. No, they're not one of the decision makers under Section 25.
They're not one of the decision makers under Section 25. So does Section 25...
Consent doesn't
Have
arise.
a look at Section 25.
Yes.
I think it would be helpful.
And there's also jurisprudence about Section 25, which in the 1990s was talking about a clinic where anorexia nervosa was treated, which was not secure because the purpose was treatment and not detention. But it rather questions this idea of a high-security prison.
Well, Section 25 is at Volume 1, Tab 1, memory stick page 32. Expressly stated in subsection 1 is what I've been suggesting, that it is provided for the purpose of restricting liberty. That is the dominant purpose.
No, the important point, which answers the problem that I was talking about, is that it simply says a child may not be placed and may not be kept.
Yeah, exactly.
End of story. Which would cut out the possibility of parents being able to consent
Yes, exactly.
to it. Yeah.
So it cuts the link.
So it does actually also curtail the power of parents.
Yes, it does. But
Oh, you just said it operates only to curtail the powers of local authorities.
well, it effectively operates to curtail the powers of local authorities, who are the only decision makers in respect of secure accommodation. But your ladyship's right that it impliedly cuts down the scope of parental responsibility. But that is an express or necessary implication, restriction. And of course, parents can remove a child from Section 20 accommodation at any time. See Section 20 subsection 8, which is incorporated expressly into Section 25 by Section 25 subsection 9.
Mr. Gordon, I was looking at Konietzki, or however you pronounce it,
Yes.
memory stick 244. Is this right? It's the applicant who described it as equivalent to a medium to high level security prison. Did the court adopt that description? And is it correct?
Yes. I think it was accepted by the court, but I need to find that reference.
Sorry, did you have the page reference?
2244,
2244.
MS 2244.
Yeah, I'll find the reference. I'm told it was accepted by the court.
I mean, it's quite interesting because they distinguish it from parental responsibility.
Yeah.
It may be worth looking at in a little more detail. It's new to me, but...
But undoubtedly, the statute divorces it from the power of parents to consent.
Yes, what as we've seen. Yeah.
But parents can remove. So we respectfully submit that Section 25 is statutorily a cut-off point. And although it doesn't answer the question that this court has to consider, it's interesting that that is a section which breaks the link with parental responsibility to consent. But even there, preserves it for the purpose of removal. Finally, on the Children Act, Section 31, again, that's at memory stick page 38, Authorities Volume 1, and that, similarly to the other sections we've been looking at, apart from Section 25, is only on the power of the court to make a care order in respect of a 16 or 17-year-old child, and says nothing about the scope of parental responsibility outside the making of that order.
Well, in fact, of course, you could say that the court can't make a care order in respect of a married 16-year-old or a 17-year-old. But if there is in existence a care order, the care order can continue until the child is 18 or in certain circumstances 19. And as during a care order the local authority has parental responsibility, that of course does suggest that parental responsibility endures until the age of 18.
Yes. Yes.
That's quite a good argument, Mr. Gordon.
To add to it, enduring to 18
I'm simply...
is 91(7). A parental responsibility order shall continue in force until the child reaches 18, unless it's brought to an end earlier. So there are a lot of similar provisions.
Yeah.
So what the Children Act does not do is relevantly cut down the scope of parental responsibility at common law. That's our main submission. And that's what all these different sections I've been eliciting to draw out.
Sorry, that was 91(7) of what?
Children Act.
Yeah. May not be in the materials. It's to do with an order conferring parental responsibility on the father, the unmarried father.
Thank you.
So the fourth point on this is the fact that Parliament has chosen on some occasions, including in the MCA and Children Act, to distinguish the position of children under 16 from those aged 16 or 17, takes the legal analysis nowhere, because it says nothing as to the content or extent of parental responsibility outside those specific provisions. And that was the rationale of the judgment of the Court of Appeal. See paragraphs 125 to 126, memory stick pages 3278 to 3279. Our fifth point as to the flaw in asserting that the MCA constitutes a complete decision-making framework is that nothing in that act operates to confer the power pursuant to which those giving care and treatment to an incapacitated person do so. Section 5 operates only to limit the liability of those undertaking acts in relation to care and treatment, rather than providing the source of the power to administer treatment in the first place. As a parent is not exercising a power conferred by the MCA in interacting with their child, but rather parental responsibility conferred by Section 3 of the Children Act, Section 5 of the MCA is not engaged. And we suggest that that's confirmed in the MCA Code of Practice. In the supplementary bundle, at tab 120, paragraph 6.3, 6.23 and 6.21, 6.2 and 6.3, I'm sorry. Section 5 of the Act provides protection from liability. In other words, it protects people who carry out these actions. It stops them being prosecuted for acts that could otherwise be classed as civil wrongs or crimes. By protecting family and other carers from liability, the Act allows necessary caring acts or treatment to take place as if a person who lacks capacity to consent had consented to them. People providing care of this sort do not therefore need to get formal authority to act. So the point about that is that the power in parental responsibility doesn't stem from the Mental Capacity Act, it stems from the Children Act.
Can I ask for your help on a really basic point? I have not entirely understood, I don't think, whether this case is concentrating upon deprivation of liberty or also includes care and treatment, because as I see the Mental Capacity Act, the two have different regimes.
Well, we accept, I think, that the argument focuses on deprivation of liberty, but logically can extend to care and treatment as well on our analysis. But
well, if you are saying that this is not a deprivation of liberty, whether it's A or B, doesn't matter, well then you are thrown back onto who has the power and the responsibility to arrange for the care and treatment of a child in this situation.
Yeah, but logically, the same principles, we say, will apply to both. But the most important point here at this stage of the argument is that the Children Act itself does not confer, the Mental Capacity Act does not confer the power to exercise parental responsibility. It is an immunizing from liability statute. Sixthly, again from the structure of the Mental Capacity Act, the Act relates to mental capacity rather than legal capacity, and that's common ground between the parties. So nothing we say in the MCA was intended to alter the position in relation to the legal capacity of 16 to 17-year-olds or the scope of parental responsibility for their parents. In other words, we say that Gillick still applies. Seventhly, although this is by no means determinative, the MCA and the Mental Capacity Transfer of Proceedings Order provide for cases to be transferred between the two courts, the Court of Protection and the Family Court, if it's just and convenient to do so. Eighthly, in L, vulnerable adults with capacity, court's jurisdiction, so that's the Authorities Bundle 4, tab 42, memory stick page 1384. Applying the principle from Shillot that I mentioned earlier, the Court of Appeal rejected the argument that the MCA provides a complete statutory code, which extinguishes the inherent jurisdiction of the High Court in relation to vulnerable adults who lack capacity for reasons falling outside of the MCA. In L, the issue was whether the inherent power of the court to make injunctions in relation to people who lack capacity for a reason other than an impairment or disturbance in the functioning of the mind or brain had survived the passing of the MCA. And the Court of Appeal found that in the absence of any express provision in the Act in relation to individuals who lack capacity for a reason other than impairment, such inherent jurisdiction as the High Court had before the 2005 Act continued to be exercisable. And if I could take you to the paragraph 57 and 58 in the judgment of Lord Justice Macfarlane at memory stick page 1412. So this is volume 4, tab 42, memory stick page 1412. Paragraph 57, Miss Leaven's submission that the 2005 Act was intended to be a comprehensive statutory code covering all matters relating to an adult's capacity to make decisions is also unsustainable because the Act itself is expressly limited to, as its title makes plain, mental capacity. The Act does establish a wide-ranging, and for those matters within its compass, a comprehensive statutory code and scheme, but the Act is expressly limited to people who lack capacity for the purposes of this Act, as Section 2, subsection 1 makes clear. And then paragraph 58, nothing in the 2005 Act makes express provision with respect to individuals who may lack capacity for a reason other than an impairment of or disturbance in the functioning of the mind or brain. Neither is there any express reference to the inherent jurisdiction of the High Court. This state of affairs is in contrast to both the Children Act and Family Law Act. So although this doesn't speak directly to the scope of parental responsibility, the reasoning in that decision is equally applicable, we submit, to the scope of the common law articulation of parental responsibility. Finally, insofar as the MCA Code of Practice assists, we say that it supports our position, but it's a minor point, and we say that it's notable that paragraph 12.16, so we find that in volume 8, tab 90, memory stick page 2705, under the common law, the person with parental responsibility for a young person is, we emphasize the word is, generally able to consent to the young person receiving care or medical treatment where they lack capacity under Section 2, subsection 1. They should act in the young person's best interests. But it's not conclusive. So, for those reasons, we respectfully say that the Mental Capacity Act cannot possibly, whether read alone or read in conjunction with the Children Act, constitute a complete decision-making framework, such as to oust or limit the scope of parental responsibility at common law. That brings me to the fourth proposition, which is that no other domestic statute has cut down the scope of parental responsibility in domestic law. And at this stage of the analysis, there are only two sections left. One is Section 8 of the Family Law Reform Act. The other is Section 131 of the Mental Health Act. And we say, with respect, that if the analysis is correct so far, it's unlikely in the extreme that these two statutes can make any difference to the analysis. But in relation to those statutes, first of all, Section 131, which is Authorities Volume 2, Tab 9, Memory Stick, page 333. This deals with the limited issue of informal admission to hospital or registered establishments of capacitous 16 to 17-year-olds for the purpose of treatment for a mental disorder. And we say that this section has nothing to do with informal treatment for mental disorders or medical treatment at all. It's also conspicuously silent as to the scope of parental responsibility in relation to children who lack capacity to consent to such admission. So although it prevents parental consent from being relied on to authorize admission where a capacitous 16 to 17-year-old has not consented, it could have, but did not provide for this to be the case where a child lacks capacity. And the contrast we submit is instructive because it strongly suggests that Parliament intended to leave the common law principles of parental responsibility intact in respect of 16 to 17-year-olds who lack capacity. And although the appellant relies on the MHA Code of Practice for the proposition that its silence in Section 131 cannot be taken as Parliament, providing that a person with parental responsibility can lawfully bring about their admission to confinement, to the extent that the MHA Code of Practice assists, it does not undermine our position. And we say it's notable in particular that paragraphs 19.47 to 19.48, Memory Stick, page 2792 to 3, leaves open the possibility of relying on parental consent to authorize an intervention, albeit not an informal admission, that amounts to a deprivation of liberty. So, in 1947, an additional and significant factor when considering whether the proposed intervention in relation to a child or young person is a restriction of liberty or amounts to a deprivation of liberty is the role of parental control and supervision. Practitioners will need to determine whether the care regime for and restrictions placed on the child accord with the degree of parental control and supervision that would be expected for a young person or young child of that age. Account also needs to be taken of the particular experience of the child or young person. And over the page, under 1948, in determining whether a person with parental responsibility can consent to the arrangements which would, without their consent, amount to a deprivation of liberty, practitioners will need to consider and apply developments in case law following Cheshire West, which may be foreshadowing this case.
The reference to that, Mr. Gordon?
Yes, the reference to that is Memory Stick, page 333.
Thank you.
Oh, sorry, 332.
Thank you.
It was 333. Oh, I'm very sorry.
No,
it's 2792 to 3 and 2795, volume 8, tab 93.
Thank you.
So that's section 131.
Basically telling you they don't know the answer and people had better think about
Exactly.
it.
But it certainly doesn't change the analysis if we're right on our third proposition. And similarly, we submit with section 8 of the Family Law Reform Act, which is at tab 8 of volume 2. Tab 8 of volume 2 of the authorities. This concerns medical treatment more generally, but only serves to confirm, we submit, the pre-existing common law position that a child aged 16 to 17 is capable of giving effective consent to medical treatment. It doesn't change the test for determining whether a child is able to give such a consent. Section 8 did not alter the circumstances in which a parent could provide effective consent to medical treatment. The wording of Section 8.1, and in particular Section 8 subsection 3, so I'll just take you to that. Section 8.3, nothing
I don't
in
think
this...
you've given us the number.
332, Volume 2, Tab 8. So Section 8, subsection 3, nothing in this section shall be construed as making ineffective any consent which would have been effective if this section had not been enacted. That suggests that it was not Parliament's intention to remove the right of parents with parental responsibility to provide an effective consent to medical treatment on behalf of a 16 or 17-year-old child.
Even a capacitous one,
Even a capacitous one.
which is very controversial.
Yeah, that is, but certainly in the context of incapacitous or lacking Gillick competence.
In fact, this is a useful point at which to put the question to you, which I put to the other side.
Yes.
Actually, I put it to Mr. Wolfe, but it was agreed to by Mr. Secretary. Do you say that parental responsibility includes the power to give a consent to treatment or to a placement of a 16 or 17-year-old to which the 16 or 17-year-old objects?
We say that the wishes of the child are important, but they're not determinative.
So a parent can override the objections of a capacitous...
Of a capacitous, I'm sorry. I'm not going as far as to say that, but all I'm saying is this section doesn't throw light on that problem.
Leaves it open.
Leaves it open. But what it certainly doesn't do is cover the position of a child lacking Gillick competence.
Well, in fact, it's really, because it provides that the consent of a minor who's attained the age of 16 years is as effective as it would be if he were of full age.
Yes.
That's what it says.
Yes.
Which rather suggests that it's applying the adult test of capacity rather than the Gillick test. Call it capacity or competence, I don't care.
Yeah.
That's what it rather suggests.
That's possible. That's possible. But it doesn't alter our overall analysis. The overall analysis is, just remind the court, in all the propositions so far, the common law is clear. No statutory regime, mental capacity act taken in isolation, taken in conjunction with the Children Act, or taken in conjunction with these subsections, changes the common law. And in case it helps, in Gillick itself, Lord Fraser, Gillick, Volume 1, Tab 4, Lord Fraser at page 167C, memory stick page 179, talking about Section 8, subsection 1, said this: the contention on behalf of Mrs. Gillick, it's 167 of the report, 167C, memory stick page 179, the contention on behalf of Mrs. Gillick was that Section 8, subsection 1 shows that apart from the subsection, the consent of a minor to such treatment would not be effective. But I do not accept that contention because subsection 3 leaves open the question whether consent by a minor under the age of 16 would have been effective if the section had not been enacted. That question is not answered by the section. Subsection 1 is, in my opinion, merely for the avoidance of doubt. So we respectfully submit that there's nothing in Section 8 that would prevent a parent from providing consent on behalf of a 16 to 17-year-old who lacks Gillick competence to consent for himself or herself. So far I've been dealing with negatives in a sense. There's nothing in any of the legislation so far that disturbs the common law position. I now want to move, if I may, to our Proposition 5, which is the Children Act. And the title really of this submission is that the Children Act ensures respect for private and family life. And this is really at the heart of the case, because there are competing interests involved in this highly unusual but important context, and that is the importance that the Convention accords to the right for respect for private and family life on the one hand, with its concern for arbitrary deprivations of liberty on the other. And we submit that the Children Act enshrines the United Kingdom's policy of non-intervention in ordinary family life, which is entirely consistent with Article 8. And this case, and other cases like it, have at their heart, we say, parents doing their best to care for their children, that's to say if they're validly consenting, many of whom have complex needs. In cases such as these, the reason underpinning intervention is not safeguarding nor abuse. It's quite different, being concerned with parents for whom their child's best interests are the crucial consideration. And the balance between Article 8, rights of the family and of the child, must reflect the core nature of these placements and be reflected in the proportionality of state intervention. Where in such circumstances a family cannot, through no fault of their own, meet the fullness of their child's needs at home, the state must support them. But we should not lose sight of the fact that in doing so, the state is providing a service. Where the state is providing such a service, it is not, nor should it be, open to state bodies to seek to dictate every aspect of the family's life, where it's neither necessary nor proportionate to do so. And so what is at the heart of this appeal, when one looks to the content of the common law as informed by the European Convention on Human Rights, is about striking that balance, that Article 8 balance. And it's only by reason of provision of such a service that one, we say, can meaningfully talk about valid parental consent. Now, your ladyship yesterday expressed concern about parents locking up their children. But the notion of a parental consent to actions at home isn't what this appeal is about. Parents don't consent within the privacy of their home. If you lock your child up, that is a unilateral action. What is at the heart of issue 5 in this appeal is the notion of a consent, parental consent in the exercise of parental responsibility. And
well, yes, but if basically parental consent is what gives the local authority or anybody else the power
yes,
to deprive, to confine a child in circumstances which would otherwise be a deprivation of liberty, if that is the situation, which it may very well be, I have a completely open and in fact very confused mind on this subject, but the same principle must apply to the actions of the parent themselves. It must mean that the parents are able themselves to confine their child without safeguards.
well, yes and no. The problem is, with children at home, it raises completely different questions, because there is a limit to the possibility of state intervention. Parents bring up their children. The state obviously has obligations under the convention where it's alerted to the situation. But we trust parents to bring up their children in the main. And in the main, systems work because we have to trust professionals. Of course, there is the danger of abuse, and that's what this case is about. It's about striking the right balance. But if one looks, for example, even at the Mental Capacity Act, there is a measure of trust in a local authority outside the dole system, maybe even within the dole system. They have to recognize a deprivation of liberty, and the state has to take action if it recognizes it. But the same problem at its fundamental heart remains. If you have, to use your ladyship's word yesterday, a corrupt local authority, the MCA isn't going to prevent abuse. So there is a point at which it becomes almost subatomic to try to provide a mechanism for solving the problem. And that really is at the heart of this case. It's providing sufficient protection to ensure that the system works. But it is not possible to provide under any act, under almost any regime.
Of course. Of course, that's the case, but one is still back with the question, because it all turns on the scope of parental responsibility
Yes.
and whether, in fact, the parent does have the power to authorise or to actually operate what would otherwise be a deprivation of liberty
Yes.
of their child, 16 or 17, capacitous, non-capacitous, without automatic safeguards, as opposed to ex post facto. Obviously, if the child's locked under the stairs at home, habeas corpus would be available, which would test the question, provided, of course, the child could get hold of somebody to bring habeas corpus proceedings on their behalf. But this does tend to happen from time to time. But what this case is really all about is prior safeguards.
Is,
Prior or contemporaneous safeguards. That's what this case is about.
well, that is the whole point. That's why I emphasize the importance of consent, because you have two players in the situation. You have the state and you have the parents. And provided that there are safeguards on the states having to ensure that parental consent is valid, whether through the mechanism of the LAC system or just through the general principles of Article 8, may not matter for the purpose of the practical problem and the practical solution. If a local authority, to take the paradigm here, because most cases are going to involve local authorities and most cases are going to involve Section 20, the need to establish, to ascertain a valid parental consent, that is to say, parental consent to something that is necessary and proportionate in the child's best interests, is the proactive safeguard, provided that it's coupled with the safeguards of requiring regular review. It's at that stage that if there is not a valid parental consent, there will be a deprivation of liberty and the Article 5 safeguards will kick in. But prior to that, we're not in Article 5 territory, except possibly for residual obligations mirrored, in fact, under Article 8, to ensure that there is a valid consent.
But can I just press Section 25 again?
Yeah.
Because the local authority is not entitled itself to deprive a child of its, to confine a child in secure accommodation without going to court
Yes.
in a longer term. So your safeguard in the parental consent situation is the local authority.
Yes.
And yet it has not, with regard to a looked after child, got freedom to authorise things itself under the Section 25 regime.
Question your ladyship and the court has to consider is whether there is a legal separation between the Section 25 scenario and the situation outside the Section 25 scenario, because Section 25 is covered by statute, whereas nothing else in the operation of parental responsibility is covered by statute, or at least relevantly covered by statute. And so we say that outside Section 25, yes. Well, I'm reminded that the local authority is the relevant authority in the dolls as well.
Yes,
So
quite.
that was the point I was making earlier, or seeking to make earlier, that at some stage there has to be a level of trust when you're balancing the various rights.
But
Yes,
as presently drafted, it is not possible to have an administrative approval under the Mental Capacity Act for this category of children.
That's right.
And so I'm still not entirely satisfied as to the difference between secure accommodation within Section 25 and the sort of arrangements that we've been talking about here.
Well, you couldn't have a valid parental consent on a section 25, not only because the statute excludes the operation of parental responsibility in that context, but also because it wouldn't be definitionally, within the definition that we're suggesting is the correct definition, of a valid parental consent, because it would not be in the best interest of the child. It wouldn't have to be under section 25. So although it's a benign regime, it's not a best interest regime. And that is, there is a cutoff. The questions here are not, in our respectful submission, what the law should be, which is or might be, which is the appellant's plea for a change in the common law. It is what the law is. And the law is governed by two elements. This is elementary: common law and statute. Statute lays down the red line in respect of section 25. For reasons we're not completely clear about, I know that the appellants have prepared a detailed note. At the end of that note, though it deals with the history of section 25, comes to no conclusions, nor are we clear about why dolls doesn't apply to 16 and 17-year-olds, despite extensive research. But that is the scope and the parameters of the law. There may be a change in the law. But what we're...
The common law is not a static
No.
body of principles or rules. It is capable of development in the light of new problems, new conditions. We all know that.
Yes.
So that's part of the mix of this. Another part of the mix of this is that the logic of your submissions is that the local authority, which has parental responsibility for a child under a care order or an interim care order, would have the same power as parents have to consent or authorize the deprivation of liberty. That is the logic. It has to be, because the local authority by statute has parental responsibility. Now, I know that we were told at the outset of this that this case is not about the powers of local authorities or indeed other people with parental responsibility, other non-individuals with parental responsibility. But I'm not sure how far we can ignore that issue.
Well, the difference between local authority parental responsibility and that of parents lies in the Article 8 right to respect for private and family life. That's the reason we have accepted the distinction. Whether it's a logical distinction or otherwise, Article 8 informs the common law, just of course as Article 5 does.
So you should say that we should at least develop the common law of parental responsibility in the light of Article 8 to restrict in some way or ways the power of institutional parents in a way which the power of individual parents, human parents, is not restricted. You're saying we should do that?
No, the way I'm attempting to analyze it is in bits. So we start off with the common law. That comes from Gillick. Gillick was not concerned with local authority or corporate parental responsibility. Article 8 doesn't change the common law, but the common law develops in line with the convention. And so that is the reason for the stand we take on this. Logic aside, there is a rationale for simply tracing a line from Gillick through to the present time, but applying Article 8 of the European Convention. And so we say the common law is very clear about parental responsibility, individual parental responsibility. We also acknowledge that the Convention informs the common law. But we say, at heart, this comes back and back and back to balancing the rights of parents against children in a context of care. And that's what, whatever I say, that is what this case is about. And we can cite authorities, we can cite logic, but the hard-edged law militates against the appellant's analysis being correct. Yes, the common law can be developed, but it can't be changed in terms of imposing a statutory framework where logically, that framework is said to alter the common law as laid down in Gillick.
But could I just pursue your point about balancing Article 5 and Article 8? That means that not only must we carefully consider the considerations arising under each article, performing a sort of Princess Caroline exercise, but in relation to these articles, but we must also be satisfied that the end result is necessary in a democratic society. And a democratic society is also not static. And could it be said that today's society, one of the societal norms is that people do not lose their liberty, not in general lose their liberty, if they have mental impairment without an order of the court or some equivalent safeguard?
Well,
That's a factor which has to be taken into account in this balancing exercise.
I'm not balancing Article 5 and 8.
Yes, Article 5 and 8.
That's not my submission, that you balance Article 5 and 8. My submission is that you have to balance the rights of parents and children to respect for their private and family life. But that balance is an Article 8 balance, that if that balance, and therefore I think each and every article of the European Convention has its own procedural protections. Article 8 is no exception. So the question is, are the procedural protections which we submit do reflect the common law now sufficient to ensure that respect, or is there some vulnerability in them which is objectionable? And
Well,
say,
you would, I'm sure, accept that children have Article 8 rights as well as parents.
of course,
And that a confinement of a child is an interference with their Article 8 rights.
absolutely.
You would accept that.
I do accept that.
So part of your argument is that there has to be a balance between the rights of the parents to control their children and the rights of children to control themselves, basically.
Yeah.
You accept that?
Well, I do accept that. The point is, your ladyship yesterday mentioned HL in the United Kingdom, a case I was in.
Yes. I knew you'd be far more familiar with it than Sir James was.
But as far as that case is concerned, I hope the court will recall that far from there being any question of consent, Mr. HL was dragged, screaming, to a mental health institution in the name of informal admission, against the wishes of his carers. That was not a consent case. And there was a clear deprivation of liberty in that scenario, which required safeguards which were absent. But this is a very different context. Here, the question is there a deprivation of liberty at all? And that is why the Article 8 balance is so important, because if you reject the notion that obligations placed on a public authority to investigate the consent of the parent are not a sufficient safeguard to prevent against arbitrariness, then you reject it. But our primary submission is that, looked at in the context of the importance that the law has always accorded to parental responsibility, save where there is a Gillick competent child, whatever age, then you don't get to Article 5 at all. You don't reach.
In Nielsen, it wasn't enough that the mother had given her consent. The consent was scrutinised.
Yes,
and
it was,
had to meet certain criteria. So consent of itself is not an absolute.
Well, consent is, the question in Nielsen was, as Sir James Mumby pointed out, the question in Nielsen was, had the parents abused their powers of parental responsibility? And we say definitionally, they will not have abused them if they are doing that which falls within the ordinary aspect of parental activity, i.e. acting in your child's best interests.
They pose safeguards on that. For instance, that the treatment which the child received, the child was only 9 in Nielsen, the child received in a closed ward with psychiatric patients when the child was not mentally unwell. They asked whether the treatment would have been the same for a child in an ordinary hospital. And that sort of question had to be asked and answered positively.
Well, it didn't determine, the court didn't in Nielsen lay down lay down the parameters of the scope of parental responsibility. What they said is it has its limits.
Yeah, but that's the same thing. They're saying that it isn't an absolute.
It isn't absolute.
Then the court has to scrutinise it, and therefore it might be said there ought to be a regular procedure for the court to scrutinise it.
Well, I'll come to the access to the court later, but it is axiomatic in our submission that the validity of parental consent is the rock upon which the Article 8 balancing exercise takes place in the context of parental consent. And so it has to be investigated by the local authority, and it has to be regularly reviewed by the local authority. But only if that process breaks down can it be said that there is a violation of Article 8. And as I said earlier, the local authority place in the DOL system or in the non-DOL system for 16 and 17-year-olds is not qualitatively different in bringing the matter before a court, because it has to recognize an issue in the non-DOL's MCA regime of deprivation of liberty for the matter to be brought before a court. Just the same way here, transposing the analysis to parental consent, the local authority has the same obligation placed upon it. And if, at the end of that exercise, it considers that there is not a valid parental consent, then it would be required to bring the matter before a court. So the court will come into this if there is an issue, but we're dealing with a case where hypothetically there is no issue. And to say, well, but how do you trust the local authority without the court, misses the point, because you have to trust the local authority even where you have a fixed Article 5 regime.
How can we be sure the local authority are going to be involved in the placement? Suppose a child of 17 with no prior local authority involvement, not a looked after child, and the parents are proposing to put the child into a NHS facility of some kind.
Well, I thought your ladyship would at some stage ask that question, and the answer is that although there isn't the LAC regime, Article 8 would impose the same responsibilities in general terms on any public body. They would have to ensure that there was a valid parental consent to admission, whether it be an NHS or a local authority institution. That must be the position, and we accept that that must be the position.
And what about a private one?
Well, a private institution is... A private institution, it can only be attributable to the positive obligations of the state for there to be state attribution. That's limb 3 of Stork. So,
Well, and that's because there is a positive obligation on the state to protect and guarantee certain rights.
yes.
The way we do that is through the DOLs or the approval of a court. And we have to look at this in terms of the possibility of parents placing a mentally disabled child in a private facility, because such is an entirely feasible possibility if the parents have the funds to finance it. So what do you say the state should do to protect the child against that being done inappropriately?
Well, I can only say that that would not be an Article 5 case, because it wouldn't involve the state.
Well, if you look at Stork, the state's responsibility was imputed very considerably in relation to admission to private clinic.
Well, in practical terms, how would the state become involved in a private institution unless you could impute the knowledge to the state? It raises different questions to the scenarios we're considering, because whatever obligations lie upon the state in a private situation, that involves limb 3 of Stork. But that's not a case where you've got the state as a player in the consent situation, where there is plainly state attributability.
But if we're talking about the extent of parental responsibility, it would be the same wherever the placement is.
Yes, the scope of parental responsibility is the same, the obligations are the same.
So
And
you're basically saying that the parents could place their child in a private facility, and you're being given some assistance.
well, I will tell the court what I'm being referred to, Section 86 of the Children Act of
Yeah.
1989,
Yeah.
where a child, so I'll read this if I may, because I'm not
Yeah.
sure it's in the bundle. Where a child is provided with accommodation in any care home or independent hospital for a consecutive period of at least 3 months, or with the intention on the part of the person taking the decision to accommodate him, of accommodating him for such period, the person carrying on the establishment in question shall notify the appropriate officer of the local authority in England whose area the establishment is carried on.
And therefore the state would have responsibility. So I think that's why I said. And there are various provisions for schools as well, boarding schools.
So the machinery is there.
Yeah.
The question then is, what are the obligations on the local authority?
Meanwhile, the child's been locked up for 3 months. It may all be all right.
Well, it's not
Mr.
all right.
Gordon, but-
It's not a question of being all right. It's a question of what obligations lie upon the state in the hypothetical, well, maybe not just hypothetical, the real situations that your ladyship is canvassing. But the point is, whatever imputation on the state there is only works if the state actually has knowledge. And the statutory machinery lays down a regime for informing the state, and when the state is informed, it has the responsibilities laid down by the convention. But before it's informed, of course, there's nothing the state can do.
Well, no, if it has a positive obligation to avoid invasions of the child's rights, well, then it has to have the machinery to do it.
But
It has to provide the machinery, which, of course, can fail because people can evade it, people may not do what they ought to do. But nevertheless, if there is an obligation on the state to protect the child's Article 8 rights as well as Article 5 rights in this situation, well, then the obligation is to provide machinery for doing so.
yes, up to a point. But
Section 86 is up to a point.
Yeah.
Presumably someone, for some reason, decided 3 months is an appropriate period.
yes,
Do we know where that comes from?
It could easily have been the law before the Children Act. I'm
Might
not
have been,
entirely sure. I can't
Yeah,
remember.
yeah.
Yeah.
I mean,
Simply can't remember.
it's impossible for the state to know everything.
Well,
And the machinery is laid down for, as we've discovered in Section 86, private institutions as well as public. But
I'm very, very sorry, Mr. Gordon. We have interrupted you hugely because this is an important and difficult case.
yes,
Obviously an extremely troubling one, with ramifications way beyond the facts of this case, which is why we're asking these questions. You had a quarter of an hour removed from your time by Sir James yesterday,
yes.
but you're theoretically supposed to stop at 12. How are you doing?
Well, I won't finish at 12, my lady, because we thought that Sir James had taken up 20 or 25 minutes of my time yesterday.
I think it was about just over a quarter of an hour. Yeah.
So,
Well, what are we going to do? Because we can't go on.
no. Well, I can speed up.
You've got 2 more points, and we will try and be quiet.
I can speed up. But your ladyship is giving me, I think, until 12:15 on that basis.
Well, yes, but Mr. Setright, are you happy to give him... It wasn't your fault, that it was the other side's fault that Mr. Gordon's time
With
has
the
been...
greatest respect, not if I have to stop at 1.
Well, we're in difficulties.
Yes.
The court is in difficulties. So
There's quite a lot that I will have to deal with
There-
in an hour.
there's a very great deal. Would we be able to sit until 1:15?
Well, I can, but it will mean
No.
that I won't be able to get
Whether you can't, we can't do that. No, we can't.
to 1:30. Yeah.
No, you can't. No. So I'm afraid you're going to have to speed up very considerably, and we're going to have to keep quiet.
Well, my lady, what we could do is provide a note after the hearing if I don't manage to cover everything.
Yes,
I
that would
fear
be
that I
fine.
won't cover it.
But you've got through the meat of your points, really, because you've also got the European Convention doesn't affect. Well, we've looked at Nielsen, Koniarski, D less so, and the other international instruments don't affect. Those are your 2 points, aren't they?
Yes, yes, they are. I was going to take the court through the LAC system. I think I can avoid that because we can provide a note on the LAC system, but it's very comprehensive and allows for ascertaining the wishes of the child, regular reviews, and so forth. But
Yes,
we can provide a note.
I don't think you need to go into that.
On recourse to the court, we would say this, that P is entitled to apply to the family court under Section 8. Looked after children have particular assistance available to them to do so through the support of their IRO, an independent visitor, to access and obtain advice from CAFCAS, who may be able to bring an application on P's behalf, acting as his guardian ad litem, in many cases from P's own parents, who'd be able to act as P's next friend. And again, we can include this in the note for comprehensiveness. And as I have already said, falling outside of the Schedule A1 MCA regime, 16 and 17-year-olds, indeed many adults, are presently reliant on local authorities making applications to the court. So it's not qualitatively different. And the local authority can apply for an emergency protection order or an order under the inherent jurisdiction. Parents can apply for a specific issue order or an order under the inherent jurisdiction. And where there is any question of the validity of parental consent, that's precisely when local authorities would bring the matter to court, as they would under the Mental Capacity Act. The next proposition is the European Convention doesn't affect the position. This takes us to Nielsen, and I think I can probably again go quite quickly over Nielsen because it plainly was a case about the ambit of parental consent, parental responsibility, and we rely on the analysis of the Court of Appeal in respect of Nielsen, which is set out in the Court of Appeal judgment. And perhaps just making 2 quick points on this. First of all, in HL and the United Kingdom, that was the case on deprivation of liberty. And at paragraph 93, Authorities Volume 7, tab 73, the court referring to Nielsen said this.
Page.
It's memory stick page 2340,
Thank you.
volume 7, tab 73. That case turned on the specific fact that the mother had committed the applicant minor to an institution in the exercise of her parental rights, pursuant to which rights she could have removed the applicant from the hospital at any time. So that was the distinction drawn by the European Court in HL as to the difference between that case and the case involving parental responsibility. Your Ladyship in Cheshire, with Lord Newburger, reached a similar conclusion. And although it's suggested by my learned friends that the court of the Supreme Court was merely recording submissions, that's plainly not the case, because the paragraph at which your Ladyship reached the conclusion, what is a deprivation of liberty, precedes the recording of submissions. So that point goes nowhere. But essentially, we say HL is the answer, the key to Nielsen. It authoritatively stated what that case decided and distinguished it from the facts of HL itself. We refer at paragraph 64 of our case to further recognition of Nielsen in convention law. Sir James mentioned this yesterday, Koniarski against the United Kingdom, DG and Ireland, and we refer to Atudore and Romania. That's Authorities Vol 7, tab 77, memory stick page 2464, where a bright line was drawn between adults and minor children, but Nielsen was again referred to. International instruments, last proposition. We say that there are three broad answers to the case against us. First, international instruments do not have effect in domestic law. Secondly, and in any event, read as a whole, the international instruments relied on do not lead to the conclusion that parental rights fall somehow to be exercised differently in the case of 16 and 17-year-old children from children who are aged under 16. And nor, finally, is there any equivalence between a disabled or non-disabled child on the one hand and Gillick competence on the other. We rely on the reasoning of the Court of Appeal, paragraphs 143 to 146, memory stick pages 3285 to 3286. Now, the first intervener yesterday, Mr. Wolfe, argued that there was no cohort of Gillick non-competent 16 to 17-year-olds who were not in that situation for reasons of mental impairment, and that for that reason there were no Gillick non-competent children who were not disabled. And we say three things in relation to that argument. First, it is possible to conceive of Gillick non-competent 16 to 17-year-olds whose non-competence does not stem from a mental impairment. For example, a concussed child refusing a brain scan would be an example of that. Secondly, the argument of the first intervener assumes that it assumes that which it needs to establish, namely that a mental impairment is always a disability. In fact, by reference to Article 1 of the United Convention Rights of Persons with Disability, not all children with an impairment will have a disability. And Article 1, which is to be found at Authorities Volume 9, tab 105, memory stick page 29304, says that persons with disabilities include those who have long-term physical, mental, intellectual or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So that does suggest that in order to constitute a disability, an impairment must be long-term. A short-term impairment will not suffice. So, for example, a 16-year-old who became temporarily unconscious after a car crash may have a mental impairment without being disabled for the purpose of the convention. And our third point relates to the first intervener's argument, which relies on a passage from Lord Donaldson, Master of the Rolls in R, that Gillick was concerned with the stage development of a normal child and that Gillick competence cannot fluctuate. That point appears to be that if a 16 to 17-year-old lacks Gillick competence, this will be because that development has been hindered by a mental impairment or disability. Now, in response, we submit that to the extent this is an attempt to knock out the types of example I've given, it doesn't work. Susceptibility to, the central question in Gillick was whether or not, and if so in what circumstances, a girl under 16 could give lawful consent to medical treatment. The court found she would be capable of doing so if she had sufficient maturity, intelligence, and understanding to make the decision. The court did not consider the question of whether competence, once gained, could be lost. However, with those central tenets in mind, it must be possible to take an example. It's difficult to see how a child who had acquired Gillick competence to consent to medical treatment but became temporarily concussed after a blow to the head would be competent to make decisions during the concussion. At that point, she would surely lack sufficient intelligence and understanding to make decisions about medical treatment, and it would be artificial to suggest that he or she retained it. And Riar doesn't take the argument any further. It's no answer to our earlier example, which demonstrates that one does not have to be disabled in order to lack Gillick competence. RIAR was not concerned with the situation of a fluctuating long-term mental illness, nor temporary impediments to decision-making. It was concerned with fluctuating long-term mental illness, but not temporary impediments to decision-making. In relation to the international instruments, we set out our points at paragraphs 75 and 76 of our case, and in relation to substituted consent at 79 and 80 and 81, and we say that, and 82. So that's a rapid trawl through the international instruments, but that's our essential position. In relation to consequential issues, we set out our case at paragraph 83 and 84. The secondary case of the appellant I think I've dealt with yesterday, because the secondary case really comes down to putting back the Mental Capacity Act Section 4 when it's been knocked out on the main argument, which in our submission is not a permissible way to do it. The nature of confinement, we have a series of passages on that between 88 to 90, and our main point is we conceded that there was a confinement below, but one has to look at the nature of confinement in the context of the exercise of parental responsibility. And so the nuanced test proposed, a nuanced acid test proposed by my learned friends, doesn't meet the problem in ascertaining the scope of parental responsibility in this context. On the issues, we've given responses to the various issues posed in the Statement of Facts and Issues at paragraph 91. So what I would like to do by way of conclusion is say this, that if we can put in a short note afterwards to fill in the gaps that there have been, I'd be very grateful, because otherwise I'm going to take up too much time for my learned friends' submissions and reply.
Well, that's very kind of you, Mr. Gordon. We'll gratefully receive any such note, provided that it arrives quite quickly.
Thank you, my lady.
And I'm sure you can, because it's the gaps that you haven't been able to fill in orally. Yes. I'm extremely grateful to you for your very deft curtailment of the rest of your oral submissions.
Thank you.
Thank you very much, Mr. Gordon. Thank you. Mr. Cowan? Mr. Cowan?
I'm sorry, I'm terribly sorry, lady. I have nothing to add.
Mr. Setright?
My ladies and my lords, I've got to condense rather a lot. What we've sought to do is to provide some technical notes in the form of a bundle which we've handed up, I hope, which will allow my oral submissions to be relatively thematic. So let me embark. We would like to try to address 6 points. First, the formulation of the case for the official solicitor. Second, Gillick competence, its origin and present form. Third, secure accommodation orders. Fourth, previous law reform. Fifth, Nielsen. And sixth, the common law in the light of what is said, in particular in respect of what the Secretaries of State as the policy holder have said. First of all, looking at the formulation of our case, there's been a forensic attack by Birmingham on the formulation of our case, including the assertion that it's changed as between the printed case and the oral submissions, in particular as regards the place within the submissions of the 2005 Act. Well, what we would say is that there may indeed have been a change of emphasis which perhaps followed appropriately, only the court can say that, upon the submissions that were received after the written case was prepared and lodged. But the objective has been and remains to put before this court all the alternatives so that the court, in an area where there is, we submit, a real difficulty and a real need to clarify, the court can have placed before it, in argument, all the possible permutations. Inevitably, some of those, in the end, the court will reject, some of them it may accept, and the court will come to its conclusion. But it's the official solicitor's task, as we see it, to assist the process by providing all possible arguments. We may have failed there sometimes, and an example was raised by Lady Hale with regard to a particular concession that we made, where my lady said, well, I'm not sure about that. Again, we've made the concession, but the court has the freedom to disregard that in coming to its own conclusion. But, may I make this clear, an important part of the choices which the court has to make and the raw material is the Mental Capacity Act. And the official solicitor has always been careful, including in the passages which were referred to by my learned friend Mr. Gordon, to describe it as not a complete decision-making framework. And as a statute in being, it is unquestionably part of the landscape. No one has dissented, we say, from that proposition. The question is whether this court, as the arbiter of the common law, should decide whether, for the vital but limited purposes that we're considering, it should be considered in certain applications to be the decision-making process. But it can't, we say with great respect, be ignored. We say that the Birmingham doesn't address, in that sense, the fact, the existence of the 2005 Act, or in that sense, the impact of the case of ZH, which my ladies and my lords have already been taken to, but the reference is Authorities Bundle 4, tab 38, MS 1269, without taking the court to it, we say it indicates, with the approval of the Court of Appeal, that the common law defence of necessity has been abrogated, where Section 5 applies in relation to adults. Nor, we say, is there an effective challenge to the proposition that, if appropriate, the 2005 Act can provide a complete framework for carrying out acts of care and treatment. And again, if one considers the Code of Practice for the Mental Capacity Act, a document which I think we've already referred to, but the reference is paragraph 1217, Authorities Bundle 8, tab 90, paragraph MS 2705, tends to bear that out. We therefore don't resile from reference to, but just as one of the ingredients of our case, and our case contains alternative ways to look at it, which includes the radical, which is the reshaping of the common law in favour of, in effect, the 2005 Act, to the much less radical, which is the retention of parental consent as an effective medium, but with safeguards, and we make no bones about it, those safeguards may very well appropriately replicate the safeguards in the 2005 Act, but those simply bracket the case put forward by the official solicitor. The court has, we acknowledge, complete freedom to decide what should be done to address this situation. My ladies and my lords, we turn to Gillick. we were asked by my Lady Hale where the term Gillick competence came from. And there isn't an explanation for that in the judgment in the House of Lords, but it's clearly made its way into common parlance, as my lady has said. So what we have done, I mean, there's a reference in the decision in Re W, which Mr. Wolfe referred to yesterday, was being used as a shorthand by Lord Donaldson in 1991, and the reference, as a reminder, but I wouldn't take the court to it, is Authorities Volume 3, tab 22, MS 736. But what we have provided, and in the interests of completing these submissions, within the time I'm not going to take the court to it, we found, Mr. Rutkeen has found an article by Philip Bealby of the University of Hull, which is entitled, rather helpfully, the court may think, in its Divider 1, The Conflation of Competence and Capacity in English Medical Law, a Philosophical Critique. Whether that is a time-saving exercise, I don't know, but it's probably going to be of interest. And it has the benefit of being structured and looking at the history of developments. I'm not going to editorialise about it now, because the court won't have had any opportunity to read it. It's not a good use from the court's point of view of my time so to do, but we provide it and we hope it helps. But whilst on the subject of Gillick competence, we do briefly take the court to the decision of Mr. Justice Cobb in Re S. That's volume 6, tab 59, MS 2012. And that's a case which, in terms of its timing, came out between the hearing of Birmingham's appeal in the Court of Appeal and the release and the handing down of the judgment. It was drawn to the attention of the Court of Appeal by us, but it's found no reference in the judgment of the Court of Appeal. And it concerns the ability of a child parent under 16, so a distinctive set of circumstances, but not one that is uncommon at all in care proceedings, to agree to the baby being accommodated under Section 20 and to consent to the baby's placement and adoption. And in it, Mr. Justice Cobb considers in some detail the concept of Gillick competence and its differences and similarities to the concept of capacity for the purposes of Section 2 of the 2005 Act. And if one looks at paragraph 14, which is MS 2012, there one can see what Mr. Justice Cobb said, and the passage that I would invite my ladies and my lords to read starts at paragraph 14, goes on to the end of paragraph 17, but the key parts we respectfully suggest are to be found at paragraphs 15 and 16. The best way, perhaps, that I can deal with matters is to keep quiet and invite my ladies and my lords to look at those paragraphs.
Yes, well, those are the same two differences that
Yes,
we have
precisely.
already identified.
Precisely so. And we say that whilst the instant case, our case, emphatically does not concern those under the age of 16, so this is something of a diversion. The official solicitor invites the court to note that Mr. Justice Cobb has taken the view that the effect of the passage of the 2005 Act is to lead to a reconsideration of the common law test for Gillick competence applicable. See paragraph 19, which follows. So again, and I if my ladies and my lords please, to be cast over paragraph 19, that paragraph 19 contains, we say, that conclusion. At least he says there's an advantage to applying relevant 2005 Act concepts and language. We say it's a perfectly admissible process, and it's entirely akin to the process which the official solicitor invites this court also to adopt in this different context. It reflects the ordinary approach, if there is such a thing as an ordinary approach in the family division of the High Court, of puny judges at that level, to the development of the law and their approach to it. The common law is a living instrument, and it reflects all sorts of changes, whatever may or may not, in this instance, have been the intention of Parliament. Further, in relation to Gillick competence, Sir James Eadie yesterday didn't make submissions in relation to the question of whether there does in fact exist a cohort of those aged 16 to 18 who could lack the ability to consent to a relevant act, but for a reason lying outside the 2005 Act. And we submit that the reality, as identified yesterday by my lady, the President, when looking at the Department of Health reference guide to consent, is that there is no such cohort. If there is no such cohort, then the overlap between the 2005 Act's concept of incapacity and Gillick incompetence in this context is total. And if we apply, reverting again to ZH, the approach set out in that case, and we don't think that Sir James Eadie took any issue with that, we respectfully submit that in that context, the statutory concept of Mental Capacity Act incapacity has now subsumed the common law concept of Gillick competence in respect of over 16s, in the context with which we are concerned. I'm not, unless the court would find it useful, going to take up the court's time in once again taking my ladies and my lords to the passages in ZH, because you've been taken to it several times, but that's the reference. And finally, on this topic, my ladies and my lords will perhaps take account of two of the, what we say are realistic concessions made on behalf of Birmingham. The test in the 1969 Family Law Reform Act is likely to suggest that it is now Mental Capacity Act capacity that applies, not Gillick competence for a 16 to 17-year-old. And second, and very distinctly and distinctively, that a parent cannot override Mental Capacity Act capacitors 16 or 17-year-olds' objections to treatment or placement in answer to the question posed by my Lady Hale. My ladies and lords, on secure accommodation orders, my lady, the President, asked why secure accommodation orders were introduced and why, in essence, that it was taken as read that a parent could not consent to the confinement of their child where secure accommodation arrangements were in contemplation. That has been taken further this morning, including by my Lady Black. But what we have done is to prepare what is in effect a technical handout, divider 2 of the short bundle that we've handed up. It sets out, as we see it, the statutory evolution of what is now Section 25 of the Children Act, but it wasn't possible within the time available to find any material explaining why the law in relation to the placement of children in secure accommodation developed in this way. So we provide the evolution, but not the explanation. None of the Law Commission reports or other relevant working papers prepared prior to the coming into force of the 1989 Act appear to refer to it, and it's not been possible to locate an explanatory note or other material in relation to the Criminal Justice Act 1982, which inserted into the Child Care Act of 1980 a provision that is very similar, if not identical, to Section 25. And in a spirit of helpfulness, we observe that it may be that the Secretary of State for Education would be able to find from archives material which would assist in tracing that development, which is important to answer the court's question, and may, because it represents the history of a provision which we say is relevant, at least by analogy, to the questions which the court is seeking to answer. It may be helpful if that is done. And if there is any further information that can be produced, we'll assist. We're happy to do further research if that will assist. So far as we can see, though, there simply was never an express consideration of the question of parental consent, perhaps because it was so obvious that a parent should not be able to consent to such a confinement. And of course, a Section 25 confinement is in a particular context, and we readily recognise that. This was the conclusion reached by the majority of the Court of Appeal in Riquet in 2000, reviewing the situation in the face of a challenge to the compatibility of Section 25 with ECHR rights. And my ladies and my lords have already been taken, I think, to Kay, but we'll give the court the reference without, unless the court would particularly like my going into it. It is Authorities Tab 3, Tab 27, MS 860 in the judgment of Elizabeth Butler Sloss, the then President, at paragraph 29, MS 873, and that is a judgment which my learned friend on behalf of Birmingham has already taken the court to. We note in this context that Kay's circumstances in the judgment appear in some respects to be very similar to those of D. K is described at 22F, which is at MS 871. Thus, K could not leave the premises and was locked in his room at night. If time allows, then towards the close of these submissions, I'm going to try to do what I was discouraged by those beside me from doing yesterday, which is to try to help with some analogies about confinement and the exercise of parental responsibility. I come now to the fourth point, previous law reform. And the first aspect of this relates to a question my lady, the President, asked yesterday as to whether there were any relevant indications from the Law Commission in the 1990s as to what should happen to parental responsibility with the reform of the law relating to mental capacity. Sir James Eadie yesterday took the court to a summary of what the Law Commission had said, but may we take, my ladies and my lords, to Authorities Volume 8, Tab 83, MS 2664, and the 1993 consultation at paragraph 3.5, looking about a third of the way down the paragraph, there begins, we say, a relevant part. And we invite my ladies and my lords to read that up to the provisional recommendation, which is in bold at 1, the new jurisdiction should extend to persons aged 16 and over. So again, I think I should keep quiet and allow the court to read it.
Well, I think we looked at it earlier today.
Yes, we go on though. We suggest that the questions posed at the end of paragraph 3.4 were prescient, and the observation as to the right approach in principle in the conclusion is apposite. The final conclusions are set out in the report at Authorities 8, tab 84, MS 2673, at paragraph 232. Were they also taken to that? And we don't think the court was taken to this precise part.
Which paragraph?
I'm so sorry. Paragraph 2.52,
2.5.
beginning with the heading age.
What's the MS number?
I'm so sorry, my lady.
It's my fault.
MS 2673. And I will invite the court to read that down to the recommendation that concludes that paragraph. Which completes the picture in that sense. The second aspect that we
Sorry, what it completes the picture in what?
of what the Law Commission was saying
Yes.
as a follow-up.
But it doesn't change the point they were leaving the common law as to parental.
We acknowledge what is said, of course. There's no more to be said about that. Yes, of course, Lord. The second aspect under the heading of law reform relates to another question posed by my lady the President, and it's about dolls. Why the dolls scheme doesn't apply to those under 18. And my lady Arden also asked whether it was legitimate to read into the fact that it doesn't a parliamentary intention vis-à-vis the operation of parental responsibility in relation to confinement. Well, like I think the others in this case, our researchers have shed no light on why dolls doesn't apply to those under 18, whether in explanatory notes or in Hansard. And the best we can do is to identify that in its analysis of responses in consultation around how to close what is known as the Bournewood gap, and my lady Hale referred to Bournewood yesterday. I can explain Bournewood briefly if the whole of the panel needs it, but I suspect that is something which will come from a reading of the document which we're handing up. That how to close the so-called Bournewood gap identified by the Strasbourg court in HL, and that the government and some respondents questioned whether 16 to 17-year-olds who lacked capacity would be included, and if so, what arrangements would govern the transition to adult services. And in our handout at 3, and I just invite the court to look at the index page to identify what the document is. So it's a Department of Health consultation report, Protecting the Vulnerable, the Bournemouth consultation on the government's proposed response, that on page 5 of the consultation response, it was noted that, I quote, others questioned whether 16 to 18-year-olds who lacked capacity would be included, and if so, what arrangements would govern the transition to adult services. So unquestionably, an area of difficulties for those, an area of concern for those in that, in age terms, transition phase, was identified. But I'm not going to go in more detail, time does not allow, to the Bournemouth document, but it may be something which, given the context, and SRK and Bournemouth are, we say, cases of importance when looking at the situation of the cohort of young people with which the court is concerned in this case and cases like it. It may provide useful reading.
Sorry, they identified it as an issue. Did they give any answer?
They didn't, no. That's a report on the consultation.
Yes, thank you.
And so it's left, like much of this case, my lord, hanging in the air for now.
Yes.
There are, we say, to the best of our researches, no equivalents to the letters sent to parliamentarians put before the court concerning the interaction between the Mental Capacity Act and the Children Act 1989. Again, it may be in the interests of cooperation and information, the Secretary of State can assist further in this regard. But we would submit that the court can read very little into parliamentary silence. Parliamentary silence is not a matter upon which too much weight can hang when looking at A, the practical needs of the cohort of children with whom the court is concerned, and B, the current statutory and social landscape. How that statutory and social landscape came about is interesting, and an absence of intention is certainly something to be fed in, but it's only an element, it's not conclusive. We say that the blunt reality is that it may simply be that the question of whether and when those under 18 will be deprived of their liberty was simply not the subject of the sustained focus that it is now, and which is apparent in these proceedings before this court. And that applies not only, we suggest, to government, but also to the domestic courts. If it were otherwise, this court would probably not be conducting this hearing, or at least not in this way. We turn then, logically, to Nielsen. And we're still not sure that the court's going to be assisted by more detailed submissions on that case, but what we have done as part 4 of our bundle of documents set out this morning is to provide a note on Strasbourg cases. That note sets out an analysis of Nielsen. It refers also to Glass, Koniarski, HL, Osman in Denmark, Stanov in Bulgaria, Otature in Romania, and attempts an analysis. We provide that because it's probably a shorter form way of doing it than my going through it orally at this stage. and we are not sure how much will hang on it. If it were otherwise, then I would have to attempt oral submissions, because we say that there is a limit to the assistance which current authority from Strasbourg provides to this court in the way that it has to determine this case. We draw the court's attention, however, to the case of Guard, which we mentioned briefly yesterday, and which I said I might need to revert to, depending on the way the submissions were made against us. And so, for completeness, there it is. I suspect that at least some members of this court will be very familiar indeed with Guard, though this, of course, is the Strasbourg determination on admissibility. And all I need do, I think, or all I'll seek to do for these purposes, is to take the court to divider 5, and in the decision of the Strasbourg court, to paragraph 99, which is on internal page 23, and again simply invite the court to read that particular paragraph.
99.
Paragraph 99. Yeah. And should we go to 100? Shouldn't I talk about that? And perhaps, my ladies and my lords, also paragraph 100, which follows on. That decision is, we think, absolutely the latest word from Strasbourg.
But it was a very special case, as others in this.
Yes, as I said yesterday, it's as distinct in most respects from the position of D as can be. If we have a difficulty, we say, with Nielsen, it's because Nielsen looks at a 12-year-old in particular circumstances, and this case looks at the cohort of 16 to 17-year-olds. The Guard case concerned a very young child indeed, and very different circumstances. So
and in that connection, can I pick you up on paragraph 4 of your note? I mean, I was looking at Koniarski earlier with Mr. Gordon. And that does concern 17-year-olds. And you distinguish, you say, the Strasbourg court said the reasoning couldn't be transferred from Nielsen. But they do that not because of the age, but because of there was an order made by the court and wasn't an exercise of parental responsibility. If anything, I think Mr. Gordon would say the implication of that case is that Nielsen is applicable to 17-year-olds when one's simply talking about parental responsibility.
It wasn't something that was effectively debated in that case, because they came to the conclusion that my Lord has summarised. We'll think about, within the next 15 minutes, whether there's anything more that I would seek to say about that case, if I may, and then...
But I think it's an important case.
Yes.
And because it is repeated,
yes,
very often is very much relied on by the other side as being the foundation of the European law on parental responsibility.
May I perhaps return to that, if I can, and see if I can complete my other submissions, and then I may be able to return to that. But we say that inevitably the end point of the Strasbourg decisions, whatever weight can be attached to them, is our domestic law and our domestic jurisdiction. And so there isn't an escape from that, which has been rightly, we say, the focus of the arguments heard by the court. We then look at the common law in the light of the arguments, particularly of the Secretary of State. And as the policyholders, they are important and are of great assistance. Birmingham have to deal with matters on the ground, but it's the Secretaries of State that are in the front line in terms of policy. Our understanding of the position advanced by Sir James Eadie on behalf of the government yesterday is that in very large measure, whilst he opposes the first case raised by the official solicitor, he agrees with the second alternative case. So what divides the official solicitor in its submissions and the government in its submissions is the balance, is how the balance, which the government rightly submits needs to be drawn between the rights of parents and the rights of children, I'm putting that very, very crudely, can be achieved within a framework that provides that parents remain the primary decision makers, as the government says, or whether it can be achieved within a framework which removes the final power to consent from them, but recognises their critical importance within a different structure. And we say that the government's case came down ultimately to a contention that it would be wrong for the court to seek to act as a lawmaker. And the same is reflected, of course, in the submissions made on behalf of Birmingham, because the court's bound to remain within the framework of parental consent, but heavily constrained. I want a tight submission on that. But we suggest that the more the submissions from the government developed, the plainer it became that the government is seeking to place weight upon an existing structure in the constraining of consent that that structure simply can't bear in a way that is adequate and effective. And second, that those statutory structures don't extend to cover all classes of person, all varieties of person with whom the court will be concerned. In respect of the LAC regime, we have made the point in our opening that it's a patchy and partial safeguard. You haven't been given very detailed submissions by the other parties on the Looked After Children framework. We don't consider it will assist, even if it was possible at this stage for me to approach that in detail orally, save to say that on its own terms, LAC is a reactive and we say an adequate framework and a partial framework. It doesn't apply, as my Lady Black identified yesterday, to the cohort of children, including 17-year-olds within local authority care. Once again, rather than attempt impossibly in the time available to deal with these matters orally, we've provided the court with a technical note, handout section 6 of the relevant provisions of the Children Act, and I invite the court to read those. A relevant and significant category of individuals to whom the LAC framework doesn't apply is 16 to 17-year-olds in the context of admission to psychiatric hospitals. The court's already been taken to section 131, a reminder of the reference, it's volume 2, tab 9, MS 333. My ladies and my lords were taken to that by both Sir James Eadie and on behalf of Birmingham. And it doesn't, we say, address the position where a child aged 16 to 17 lacks the mental capacity to consent. Subsections 3 and 4 apply to 16 and 17-year-olds with capacity. And the code of practice makes clear that a patient without capacity can still be admitted on the basis of the operation of parental responsibility, although it's ambiguous as to whether that can take place where the 16 to 17-year-old may be confined. And so we invite the court to read, but not now, subsequently to this oral hearing, paragraph Authorities Volume 8, tab 93, MS 180 to 181, paragraphs 1944 to 48, and paragraph 1957, MS 183, which is headed Practitioners will need to consider and apply developments in case law following Cheshire West, and the overall heading is Deprivation of Liberty. Do I have a note?
Well, we've just been looking at that.
Yes. So I'm not going to make any further submissions on that.
I don't think 180 and 181 can be the right page reference. Never mind.
2781, I think.
Yes.
Yes, it is. Yes, yes, my lady.
Yes, what?
We say that an informal patient in a psychiatric hospital is outside the scheme of safeguards. In the Mental Health Act, 1983, and it's important to note that many psychiatric hospitals are private facilities, and that carries with it the inevitable risk that those who may be guiding the parents in their thinking may have a range of motivations without necessarily using the term corrupt, which came from the court, which may not necessarily be entirely consistent with the interests of the child. And we do provide an analogy. Here it is. I'll try to make it as compact as possible, which reflects some of the points made by my Lady Black and my Lady the President. Take this example, which relates to both care and treatment and deprivation of liberty. Parents have a 17-year-old child. The parents believe as it happens rightly, that the child is an homosexual and has entered into a relationship of some kind with a 19-year-old of the same sex. They are immensely concerned about this. Their own views are that such activity is immoral and deeply damaging, and they believe that their son must be ill. They determine in his best interests, utterly sincerely, to do something about it. Their initial recourse is to confine him to the house and to remove his mobile telephone and other access to electronic media to stop communication with the 19-year-old, to do their best, thereby, entirely in their son's best interests as they see it, to stop the relationship in its tracks. Further, they contact a professional in psychiatry who can offer a service of aversion therapy, which involves the use of electric shock treatment. Then the court can consider two scenarios. The first is that that treatment is provided at home by the consultant who comes in and does it while the child remains confined. The second is that that consultant runs a private clinic and the parents take their 17-year-old to the private clinic with instructions, ergo consent, to contain the child, to ensure that he doesn't have access to a mobile telephone, and to carry out the treatment, all in his best interests. The program of treatment is said to be one that will last 2 months, following which it is likely that he will be, in the view of those concerned, open parenthesis, cured, close parenthesis. I suppose a third possible variation would be that the treatment was in an NHS hospital. The consultant equally sincerely believes that the aversion therapy is in the child's best interests, and so is the detention, and completely agrees, and utterly sincerely in professional terms, with the view of the parents. We say that in all of these scenarios, it's very hard to see how the 17-year-old has any effective degree of protection or even any effective voice. And it's not a far-fetched scenario at all, because in the cohort of the population of this country, which consists of people of all sorts of cultural, social, and religious ideation, although these views would be a distinctly minority view, they are present. And the official solicitor says that that may provide an example of a problem which quite simply wouldn't be addressed adequately in the present state of provision in this country. I'm not going to develop it, but I provide it because it is an opening point for consideration. And we say that the government's answer, notwithstanding, is that it's simply not possible for the court to act as a legislator. We say there isn't actually a need for the court so to act. The court, as the arbiter of the common law, can decide whether in 2018, and in the light of cases such as HL and Sheffield West, it's right that a parent should be able to consent to the confinement of their child. And if the court decides that this is simply not right, then this will require action on the part of those who are carrying out those confinements. Doesn't amount, this court reaching that conclusion, to legislating. The court can further decide that the presence and effect of the 2005 Act as a comprehensive decision-making framework in relation to delivery and care and treatment means that it's no longer necessary or desirable to maintain the linkage between parental responsibility to seek the right care for a child and the power to consent to that treatment that was once required. And we refer the court to the judgment of Lord Justice Macfarlane in Re L, which is at paragraph 57, MS 1421. We'll try and give the court the volume. And we also remind the court of the hysterectomy and sterilisation case of E, which provides a further example, we say, of an old decision which, when looked at in 2018 terms, is simply not tenable and not likely to be replicated. I said I would return
You were reading that last passage of where you formulate your case as to why we're not being asked to legislate. I'd be quite pleased to see that on a bit of paper, because it's obviously a very important part of your submission.
Then we shall.
Thank you.
I did say that I would return to Koniarski, which I'll do in a few words. We say that that is, may I have a moment? This case, D. Yes. We say that one can distinguish Koniarski because the present appeal, D, is about a situation which would not need to come anywhere near a court. And Koniarski doesn't have an element of balancing Articles 5 and 8, which is the point raised by my Lady Arden. as is the case here. And that is something I'm going to come to briefly. So we say it's a different case. We say that we don't seek to downplay parental responsibility. That responsibility, we acknowledge, runs in law to age 18 as a matter of factual, inescapable legislation. And morally, what's more, it will run, in the case of the majority of parents, very much longer. We reflect that whilst legally there's a cliff edge, a qualified cliff edge at 18, the parents of D are likely to have exactly the same feelings for and about him when he's 17 years and 364 days, and when he's 18 years. But we say that nevertheless, one has to look at practicalities. We don't seek to downplay the requirement that the parents' views are considered in the decision-making around a 16 to 17-year-old. We noted in relation to observations by my Lady Arden yesterday, the case of Tracy, which provided that a failure to consult with a parent, in that case before imposing a do not resuscitate notice, would lead to liability on the part of the medical practitioner. We've handed up in the bundle at divider 7 the case of Winspear, which follows on from Tracy and applies that to those lacking capacity. And we simply invite the court to read the headnote of Winspear and Sunderland NHS Foundation Trust. And I must invite my lords and my ladies and my lords to read it probably quite quickly. If I'm going to finish by 1 o'clock, perhaps it's something that the court can look at after these submissions have been concluded. We submit that the Winspear approach makes it clear that shaping the common law so as to require practitioners to adopt the Section 5 Mental Capacity Act framework won't lead to a diminution in respect for the voice of the parent. Indeed, it crystallises the clear consequences that would follow if that voice is not listened to. Article 5 and Article 8, we say that the balance is important, and we say that in those circumstances, it is Article 8 that must bow to Article 5. There is a balance to be drawn in context, and if the court would find it to advantage, we can prepare a note on the balance between Articles 5 and 8, which is something the court is likely to be considering. Finally, we remind the court with respect that the official solicitors raised the points that we've done so that the court can be informed about choices. It's where we started out. We think those choices have probably been cut down from the 4 which we started out with, because I don't think, even after the submissions carefully made on behalf of Birmingham, no one's quite suggesting that nothing at all should be said or done. All are agreed, I think, that there's a need to ensure that there are appropriate steps to secure protection for the rights of 16 and 17-year-olds in the position of D, although I'm bound to say that detailed proposals haven't been made by anyone, including by the official solicitor, in respect of the alternative proposal to the court. That is because we say it's difficult to see how this can be done. We still outline our primary case as the best utilitarian option because it's structurally achievable. If the court decides on the balance of interference the balance when looking at the rights of parents and the rights of children, that it prefers the alternative case or some other solution. Well, we appreciate that, but the one thing which the official solicitor does say is that there's a need to ensure there is no uncertainty. Taking our hypothetical example and looking at the most basic level of protection for that 17-year-old, if a professional person does become involved, even on a private basis, it would provide a huge measure of protection if that professional person was able to understand that there were clear dividing lines and what had to be done, and that might include the operation of, by analogy at least, Section 4 of the 2005 Act, and then at least a scrupulous professional, even one who took a minority view on things like aversion therapy, might be able to give at least the opportunity for a conflicted, overwhelmed, uncertain 17-year-old to have a voice. But we recognise this is an extremely difficult area. Children need certainty, parents need certainty, and professionals need certainty as to what to do in difficult, fraught and fast-moving situations. And the present situation is a disservice to all three of those groups. We've done our best to indicate what possible answers there are, but we recognise that probably all these submissions are inadequate in the face of the task which this court will now grapple with. I'm sorry, I've overrun slightly.
Only very slightly, Mr. Setrak.
And we will provide material as requested, including the note requested by my Lord Cornwall.
Hopefully any note that is provided on either side is exchanged and agreed, if possible,
Yes.
rather than
Certainly.
to have...
It's a collaborative endeavour,
Yes.
I think, to put the court in the best possible information to reach conclusions.
I believe this whole hearing has been a collaborative endeavour to try and work out what is the correct solution to this extremely difficult problem. The court is grateful to everybody for their submissions, and that includes the assistance which the juniors have undoubtedly given their leaders, which has been visible throughout the hearing and in the documents that we have read. So thank you all very much indeed. We will now go away and try and work out what the answer is. Court will now adjourn.